When drafting a contract, two major considerations should guide you. 1. You need to know your goal and how to get there. 2. Write down the expected actions by the parties in clear, specific, and precise legal language. Let's start with setting your own goal and path. In order to prepare yourself for negotiations, you need to set out your goals and expectations precisely in writing before entering into negotiations. It might also be helpful to write down what you don't want. Be as specific and detailed as possible. All this will become your negotiation guideline. It goes without saying, your negotiation guideline is strictly confidential and not for the eyes of the other party. Let us now look at the second consideration. The contract is a tool that transcribes all actions and obligations into binding language. Your contract needs to contain all aspects that are important to you, and they need to be clear. The language needs to make the expectations of the contract clear to any scientist or lawyer involved. When negotiating and drafting an ABS contract, the text must be coherent, because unlike other areas of law, there is no existing body of supporting law applicable to ABS. If a court has to deal with your ABS contract, it will not be able to refer to a precedent to find a solution. So, if your contract is not precise, the court will make a judgment solely based on its interpretation of the wording in your contract. If this is not clear, the judgment may not go in your favour. So, precision is key. Avoid formulations that leave room for interpretation. Take, for example, the word reasonable. If you ask 10 lawyers, you will get at least 11 opinions on what reasonable means. Not helpful. And even when you think all negotiating parties are talking about the same thing, benefits, for example, they may have different things in mind. Specify and make sure everybody is on the same page. Always bear in mind that unspecific terms and imprecise formulations will most certainly backfire. Ambiguity in your ABS contract may result in an unenforceable contract. Therefore, always eliminate ambiguous words and terms. And there is another important aspect. As we have learned in the previous lessons, your ABS contract needs to be dynamic, especially when it comes to benefit sharing. Remember our example. At the negotiating stage, it was impossible to foresee the development of a scar cream or the innovative Band-Aid. Yet, the ABS contract needed to cover the benefit sharing for those and other developments. In order to do so, the terms of your ABS contract have to be formulated in a technological neutral manner and need to cover unexpected events and research results. Avoid being too narrow. Also, make sure to clearly define trigger points and consequences for non-actions. These are your 3 takeaways. 1. Be clear and precise in your ABS contract. A judge or external persons need to have no doubt about the rights and duties of all parties at any given point. 2. Contract obligations must be clearly stated, including specific trigger points for their fulfillment. That includes methods for calculating payments in relation to benefits. 3. Your ABS contract needs to specify the consequences and actions to be taken if there is a violation of any of the obligations of the contract.